our theme for tonight is very much about accessing your rights. And I suppose this year has been a very big year, I think, in terms of that, and certainly we would hope that it may even be a bit of a sea change in some issues. There's obviously been a lot of we've had court cases, we've had students in the High Court prior to the Leaving Cert around the issue of race and exam accommodations, the Ombudsman's for Children's Office as well as the main Ombudsman's Office have been dealing with quite a significant number of complaints. Again, a lot about race, but also about other issues in terms of maybe with schools and things, issues around provisions in school as well. And I suppose they are very important mechanisms for people to seek redress, to have somewhere to go when they feel you're not getting your needs identified, you're not getting your needs addressed properly, that there is a mechanism to take that further, and that's incredibly important. I'm not sure if, can I just do a little straw poll and see how many Dyslexia Association members we have in the room, or how many people maybe are, and do we have some people that are relatively new to the whole area of dyslexia? A few as well. Okay, so what I'm going to do is just for the benefit of those, just do a very brief little bit about the association, and very briefly a little bit about dyslexia, and then just talk about some of the sort of key areas in a little bit more detail, like race and DARE, some of the sort of things that can be challenging, some things where changes have happened, and some where changes are very much needed and actually imminent in some cases. So in terms of ourselves, the Dyslexia Association has been around for over 40 years now. For more than half that time, it was a completely voluntary organisation set up to work with and for people with dyslexia, both in terms of providing services and supports for children, adults and parents, but also with a very much a strong role around raising awareness and advocacy and campaigning and trying to get people to have a better understanding of what dyslexia is, how it impacts on individuals, and the needs of those individuals, and trying to get those needs adequately met within, whether it be school systems or other systems like that. Dyslexia obviously is quite a common learning difficulty. It affects up to 1 in 10, primarily with difficulties in literacy. Fluent acquisition of reading, writing and spelling would be very central, but also with a lot of challenges around memory, working memory, speed of retrieval of information from long-term memory. So obviously you can see why particularly things like exams can be very, very challenging for many people with dyslexia. You're under timed pressure, there's a huge amount of reading, a huge amount of writing, and unfortunately, until the way that we assess students becomes more modernised, we're stuck with the system that we need things like reasonable accommodations in those exams to give students with dyslexia some hope of accessing the questions, getting their thoughts down on paper or on computer or whatever, things like that. So while I suppose our advocacy work in terms of with the government or with various agencies like the State Exams Commission or the Department of Education can be quite mixed, because on the one hand we're trying to seek changes to systems like the reasonable accommodation system for the Junior Cert and Leaving Cert exams. On the other hand, we're also saying, really, if we had a better system that had more continuous assessment, more project work, that allowed students to demonstrate their knowledge in different ways, that wasn't all just about written responses in a timed exam, then a system that was designed well, that was very inclusive, possibly wouldn't need or would need very little in the way of accommodations in exams. So there's always that kind of double-edged sword sometimes when you're talking to the department. It's make the current system better, but really ultimately we want a new system for some things. In terms of exam accommodations, that's particularly been I suppose a hot topic this year. As I said, we've had court cases in the High Court around students who really felt that their needs were not being properly considered or addressed in the process when they had applied for and then been turned down for these accommodations. The Ombudsman's Office, and Nuala will talk more about that, have been dealing with a very significant number of cases around that. And I suppose what's really positive is the State Exams Commission is beginning and is in fact about to make some significant changes to reasonable accommodations. I actually got a phone call this afternoon to say that they're launching next Thursday, the 13th of October, a new scheme in relation to reasonable accommodations. we have no details about that yet, but certainly we would be quite hopeful that there will be some positive progression in that in terms of the process of reasonable accommodations. And certainly as soon as we know more, we'll be letting our members know and trying to get that out in terms of, you know, social media and the like. I know they're also going to be doing some meetings with schools as well about that, because the reality is that for students who are sitting their Leaving Cert this June, normally they would have been applying for their reasonable accommodations in their Leaving Cert exam by May of this year, whereas they haven't even been able to apply as of yet because of this whole uncertainty and the fact that the state exams is reviewing the process. So certainly we would be very keen and have been very keen in all our meetings with them along the way to sort of push the speed of this process, because obviously these students know, and any of you who are parents or were that student with dyslexia and Leaving Cert, the earlier you know and the earlier you know what your Leaving Cert is going to be like, you can relax somewhat, hopefully, if you've gotten what you wanted and what you needed, and you can sort of settle down and concentrate on the work that you need to do. So obviously this time next week, hopefully we may have some positive news, or certainly some movement in the right direction, and we'll be able to talk about that then. One of the other areas we'll say that's been very positive this year as well, and very much linked with the sort of the advocacy work, I suppose, that we've done with them, is the DAI, the alternative entry process that's operated by quite a number of the third level colleges. And this is a process whereby students who have a disability or a specific learning difficulty like dyslexia can apply through DAI, which is through the CAO. You tick a box in the CAO, and then they ask you to provide additional information in terms of evidence of your difficulty, and also then evidence of the impact that that's had on your learning. The HEA and the organisations at the third level colleges who use DAI themselves did some research about 18 months, 2 years ago, and identified that the DAI process in terms of how it was set up was hugely inequitable. They were asking for students to submit an up-to-date psychoeducational assessment report, you know, confirming that the student had dyslexia and their level of need. But the reality in Ireland today is that for most people, the only way you can get that assessment is with a private educational psychologist, because the school system is so under-resourced and understaffed. So the impact of having that requirement meant that the students who got there were hugely skewed towards people in higher socioeconomic brackets who were actually able to access it. So that requirement was effectively became a real social exclusion barrier. And thankfully DAI were aware of that and were very open to, I suppose, campaigning from organisations like ourselves to actually get rid of that requirement to have an up-to-date assessment. I mean, I know we've always thought, and parents regularly say it to us on the phone, why do I have to, you know, prove yet again that my child is still dyslexic? One of the things we know about dyslexia, the brain of people with dyslexia works differently. That doesn't change. The impact that may have on them may change depending on their environment, you know, depending on their age, different things like that. But them being dyslexic does not change. So certainly getting rid of that requirement for the up-to-date report is, I think we say, another certainly very big positive for this year. And we hope that that will begin to have an impact in other areas as well, and maybe have a trickle down into other accommodations and things like that. So I suppose for a lot of people in terms of race, the exam accommodations process, as I say, normally under the old system, you applied if your student was doing Leaving Cert by May of 5th year, gave all your documentation, your evidence, school filled out the report, maybe provided samples of written work. Chances are you didn't hear until maybe January of the Leaving Cert year whether you'd gotten it or not. If you got it, great, you were happy and you continued about your way. But for a lot of students, they don't get it. And for them, there's a huge crisis in terms of, okay, what do we do now? So obviously the first thing is trying to find out, why were you turned down? And certainly that was a huge issue for a long time, and thanks to work done by the Ombudsman office, a lot of pressure was put on the State Exams Commission to basically say it's not reasonable to not say why you've been turned down for something. So certainly now they are obliged and have committed to telling people why you haven't got something, at least then you have some grounds in which to frame your complaint. And there is an appeals process within the state exams reasonable accommodation system that you can submit an appeal. Unfortunately, they don't give you a huge amount of time in which to do that. It's usually only a matter of weeks. So I suppose it does mean that it's really important for parents and teachers and schools to be on the ball and communicating promptly with one another in terms of if you do need to go through that process. So there's an independent appeals group that the SCC brings together to look at any appeals that come in. Only I think about a third of them maybe might get overturned in that appeals commission. So then that leaves another two thirds then will say you are being told, no, we're still saying you're not getting it. And I suppose tonight is very much about looking at in situations like that, and also in other situations, for example, where people are unhappy with school and maybe you've tried to deal with the principal and the board of management and yet you still feel they're not listening or not addressing your needs, is then I suppose it's moving on to the next phases in terms of what's available to you and the really valuable work done by organisations like both the adult and the child Ombudsman's office, because basically once you hit 18 you go to the main Ombudsman, and under 18 it's with the Ombudsman for children. So I think I'll probably maybe hand over to Nuala at this stage, and Nuala is going to take you through I suppose essentially the role and the remit of the Ombudsman for Children office in terms of when they can step in and what they can do, and maybe possibly even give some examples perhaps of some of these sort of dyslexia related cases that they've addressed and investigated.
So we're the Ombudsman for Children. We were set up back in 2004, and the first Ombudsman for Children was Emily Logan. So she was our Ombudsman for nearly 10 years. And so our second Ombudsman is Dr. Niall Muldoon. So he was appointed back in 2014. So what we do basically is the role of an ombudsman is to uphold the rights of citizens in a country. And we do that by looking at the administrative actions of various public bodies. So under our legislation, we can look at government departments such as the Department of Education, schools, all other state examinations. Commission came into our remit back in 2014 or 2013. So that was the first time they came into our remit. It was because there was a change in legislation. So we can look at hospitals, we can look at TUSLA, the Child and Family Agency. Housing, as you can appreciate at the moment, is a major issue for us, especially in relation to children that are experiencing homelessness. So we have a very broad remit in that we look at all different types of public bodies. But again, it's specifically about the administrative actions. So that I'll talk about that a little bit more in relation to this piece of work. We also have other roles, and that's about educating children about their rights. So in our office, which is just down in just off Jervis Street, we have every week we have classes. We've 3rd, 2nd, 4th, 5th post-primary schools, children that come in and learn about their rights. So it's an interactive workshop and it's really successful. I think we had over 1,000 children last year, and that's been going on for a number of years. We also monitor legislation. So if the government is putting in a new piece of legislation, we can advise on it, say it draft heads of bill, but we can advise on whether or not we think it upholds the rights of children. So if any of you are particularly interested in relation to the legislative side of the House, if you go onto our website, which is www.oco.ie, you will see all about the different types of legislation we've advised on. Some of the legislation might arise from some of our investigations. So for example, a number of years ago we did an investigation in relation to one child that couldn't get a school placement. I think it went to 26 schools and couldn't get a placement. So as a result of that, we advised on the admissions, the Original Education Admissions Act, which I know is taking a different format this year, but it's all about levelling the playing field for everybody in terms of access and education. So I can talk a lot, so stop me at any stage, okay? I can go off just any time. I won't be at all insulted. So at a higher level, we also express the views of children. So what that means is that we can consult with groups of children and to ask them to tell us about their stories, about their lives. So we've maybe in the past, around a couple of years ago, we went into St. Patrick's Institution, which was an institution where children were detained between 16 and 21, and we went in and got the boys, the lads in there to tell us their stories, and we published that. It was another way of trying to influence change. So in particular in relation to children with dyslexia, as you may know, Ireland was examined by the UNCRC, the United Nations Committee on the Rights of the Child, back in Geneva earlier this year. They published their observation on how children are testing us in relation to our rights. And part of what we did is that we consulted with some of the children that come to us and raised complaints. We recorded them. We did a report on what they've told us, just different stories about different parts. And the one story we did include was Emma's story. Obviously that's not a real name, but Emma's story, which was what it was like for her when she was refused. She found out a couple of weeks before her leaving certificate that she's a young girl with dyslexia, that she wasn't getting her accommodations. So throughout her whole educational career, she'd been getting supports. She got supports at junior certificate. She rightly expected that she would get them at leaving certificate, and she didn't. And she tells that story, and we put that story to we put this whole book to the United Nations Committee to demonstrate the impact on children. So that story was very powerful. And again, if you were interested, you can go and it's on Emma's story. You can just click on it under Word to the Wise, and you'll hear her story. And so I do think it was just very powerful about what had happened, because as she said, she got through to 3rd level and she got all the support she needed. So it's that whole disconnect between a child's journey through our education system just doesn't make sense. So that's just to let you know, because part of the concluding observations, because obviously we made quite a strong case along with other NGOs in Ireland, the concluding observations is particularly that they made a specific recommendation, I'll just read it out now, that Ireland, the State of Ireland must uphold, is to establish a clear and objective framework for ensuring that children with disabilities are provided with reasonable accommodation for their education needs, including in the context of state examinations. So we're delighted that it's in, and it's a very clear recommendation in that regard. So we deal with lots of complaints, but we have to find evidence of maladministration, so that they failed, there was an error either through the actions or inactions of the public body, and there's an adverse effect on the child. So that's really important. Those two things must be in place in order for us to examine a complaint. So we're independent, we're free, we're impartial. And that's really important, because we're not an advocate to the child per se, and we're not an adversary to the public body. We keep a straight line. So we try to make sure that we always uphold that, because that's a very basic principle of an ombudsman's office. So we get lots of complaints. Our annual report was just launched last year, so if anyone's interested, I won't go all to the breakdown about it. So in relation to SEC, we received 132 complaints in 2014 and 2015 about the State Examinations Reasonable Accommodation Scheme. Now, the challenge is, and this is very important, we can't overturn, if a child does not meet the criteria as set by SEC, we can't overturn that decision unless there was an administrative error. So what that means is so a lot of the times we get ready for these complaints, we get ready to parents, because sometimes a lot of parents don't know where else to go. They get this letter saying, oh, you didn't get it, no explanation provided, and they're in bits and their child's in bits, and they don't know where to go. So a lot of the times we spend on the phone talking to parents, advising them to go to the appeals mechanism, this is what you can do, this is how you set out your appeal, and so on and so forth. So we do a lot of that. So at any stage, just be aware that you can contact us. And then what we do then is, if we get a complaint that we feel there may have been an administrative error, we send it to SEC. So we're in regular contact with SEC. We send a complaint. If a complaint comes into us in writing with support and documentation, and we believe it should be reviewed by SEC, we will send it to SEC. They can either uphold it, or in a small number of cases, around 8 cases, they have overturned their original decision. So for example, we found one child, his attainment tests were based on an ordinary level paper rather than higher level paper. So obviously he was retested, and he fell in within the criteria. And another child, in another case, there was the standard reporting, the standardised scores weren't appropriately added up. So again, it was just a very simple error that it wasn't picked up by SEC, hadn't been picked up by the appeal board, and was subsequently picked up. So, but it's just to be very clear, just to manage people's expectations, because we can't overturn a decision because it's about the attainment scores, but we'll just look at the administrative error. the one key message when I left the office today, and I told obvious people I was coming here, is Aidan Hunt is our casework manager. And he has said, if there's any questions, great faith in me, if I can't answer and there is anybody in the room that has a question, then please contact him. He is more than happy to take your call, and I'll have the contact details here. The reason I'm asking for advising about Aidan is he has been dealing with the SEC complaints in our office for the last 2 years. So he's very experienced. So that's just please don't, if I don't cover everything, he will have it. There is a part on our website in relation to if you've concerns about a decision by the State Examinations Commission. So that whole section is there that will talk you through what we can and cannot do. So I think that's very important. But after 2 years, and we had regular engagement with SEC, we were very concerned about some general administrative issues. And what we mean by that is a lack of rationale, poor communication, not explaining why by parents or to children about why they didn't get what they expected to get. So we decided then that we published there in June 2006, we did an overview. And basically we made some just key findings, which was we felt that the scheme was unfair. And what we meant by that, it is unfair for a child going into one of their most significant state exams in their life, will make huge decisions about what their next step will be. It's unfair for them to only find out in their final year of their exams, or in some cases weeks before, that they're not going to get, or they may get, but to have that level of tension and emotional distress already in a very emotional time, we just felt that was unfair. So what we mean by that is that the criteria are the same at junior cert and leaving certificate, but the decision making as to whether or not a child will be granted the accommodation is different. So at the junior certificate level, a school carries out the attainment test. The school makes a recommendation as to whether or not whether or not a child should be granted accommodations and the type and nature of accommodations required. That is sent to SEC and they endorse that decision. So that's fine. When it gets to leaving certificate, the same process applies, except because the SEC say it is a higher stakes examination, then the National Educational Psychological Service, NEPS, they make the decision. They look at the application and they make the decision. So it's a different system it's a different decision-making system. And because of the impact on the children so close to their exams, we just felt it's unfair. We also raised concerns about communication. I think you've covered that very clear, and they have done well. And in fairness, SEC are very open, and we've made some recommendations. We've met with them recently. We can't speak publicly about their plans, but I'm sure it's going to be exciting.
Well, hopefully on the 13th we'll be happy.
Yes, yes,
happier.
Come to us.
Happier, yes.
Yeah, happier. No, I do think it's quite so, because obviously as the result of that, we made some recommendations as part of this report as well. While they are given rationale, part of what we want to say is that the rationale needs to be very clear. So sometimes people were getting standardised less than 80%, more than error rating. We're going, that means nothing unless you have an actual qualification yourself. It needs to be really clearly explained what exactly this means, so teachers can explain it and that children can understand it as well as parents, because children need to know. They need to know understand their own needs and what they need going into the future. So we raised that as well. And also we wanted to raise about the oversight of the scheme. We totally respect the view of SEC that it is important that no one is unfairly advantaged or disadvantaged by being given accommodations, and the integrity of the exam must be protected. No one would challenge that. It has to be a level playing field for everybody. So, but what we raised with them is about the quality of the oversight of the scheme. So they gave us a lot of information and data, but we felt a very fundamental issue, for example, would be that you could track if a child was given a certain accommodation as junior cert, were they given the same at the leaving certificate, and if not, why not? So that they should aggregate the data to be able to understand, because that'll be a very quick way of seeing is there a huge discrepancy in terms of how the scheme is administered. So that was our one of our recommendations. We also recommended that while obviously the scheme is for specific learning disabilities, we felt it should consider extending it to children with general learning difficulties. So the children that just need possibly a bit more time in order maybe an extra half an hour to do in exams, that they may not have a specific, but they'd have general learning difficulties, and about whether it is fair that they're excluded from the scheme entirely. So that was the main recommendations. that we made to SEC as part of this report. And again, this report is on our website. And we were talking about audit and review, and that they should ensure that the scheme is consistently administered, so that is fair. We met with SEC subsequently. We published this in June. We met with them recently, and so they have endorsed our recommendations, and which is great. And again, I can't speak because in fairness to them, it's their story to tell, and it's their change. They carried out a big review themselves, a very serious review and reform of the scheme, which is very significant, I understand from what they've said to us, which is influencing the changes that are coming down the line. So we're going to watch this space, but we sincerely hope that we won't get any complaints next year. That's our goal, no complaints. That's our goal. Is that okay? All right, sure? That's grand. Didn't talk too long, did I?
No, that was
sorry.
super.
No, sorry.
I think that was a wonderful run through. Yes, exactly the road, and also I think the achievements. And as you say, while I know the Ombudsman's office, or as you say, you have that very clear line you have to abide by, and you do very well. Nonetheless, I think actually having an Ombudsman, having someone who is seen to be fair, to be impartial, but also who has a weight under law to actually make recommendations, and actually that those things have to be listened to, so I think that's incredibly important, and we're, on behalf of all the students with dyslexia, I think we're all very grateful for the work the Ombudsman has done in really highlighting this, and pushing it further with the SEC.
Oh, that's great. That's great. I'll tell the team, because I think I would know that would be an awful lot to them, because sometimes you can feel you're not getting anywhere, so it's great to hear that.
Yeah. I think even as an avenue for people to go for that advice as well. I was really interested for you talking about that people can ring even for advice about the appeals process and things like that as well. So that's an important, and again, another avenue for people to go and get advice, because I think if any of you have been through it, that appeals window with the State Exams Commission with their appeal is very short. It's literally a couple of weeks, best case scenario. So the more people you can call and get a bit of support in terms of doing that, give yourself the best chance with the appeal, obviously the better.
Oh yeah, absolutely. And there's a lot of experience. Like I said, our team's been dealing with this in a couple of years, and they've been dealing with a lot of parents and children, obviously directly as well. So don't hesitate to ring. That would be a key message I got from my team today when I was coming down here.
Thank you very much, first of all, for the invite. And I always think that when I come to events like this, and I do a lot of talks in terms of educational supports and care supports for young people with additional needs, I'm always very conscious that I'm perhaps the least expert person in the room. And I always think that perhaps those in authority who think that the least expert person in any room is the parent, I always start off with the view that in fact parents are the real experts in their children's lives, and that in fact parents for too long are shut out of the educational process, and that there is such poor levels of communication between schools and parents that is often, from a children's rights perspective, which is my job, is that there is a lost opportunity there about considering what is in a child's best interests. I suppose my background is that I am a children's rights solicitor with a Dublin law firm, and I primarily deal with children in three different categories. So we have children in the criminal justice system, children in the care system, and that's where I was today. And then in addition to that, children with disabilities. And children with disabilities, of course, is a huge umbrella term. And when we are talking about children with disabilities, it's about supporting families with children with disabilities and additional needs in a range of areas, so whether it's in relation to healthcare, it's in relation to education, or in relation to other social supports. I'm also coming from a background where I have to be very careful about teachers, because my father was a school principal in County Fermanagh, and my mother was a teacher in Enniskillen, so I'm also very conscious that I can't dump on teachers too much. But let's put it this way, I do a lot of talks around the country, and if I was doing talks 3 years ago, and I was saying this at a conference in Kilkenny on Saturday, that when I was doing, if I was doing talks 3 years ago, I would have seen that in different parts of the country, people had different challenges. So what might have been a difficulty in Donegal may not have been a difficulty in Carlow. What might have been a challenge in Waterford was not a big issue in Limerick. Whereas I'm finding that in the last number of years, there is a greater consistency to the challenges that parents face and that young people face, both in health and in education. And I think therefore there's a challenge on the policy front to ensure that in fact we have greater consistency across the board. I know that there is somebody here from the Ombudsman for Children's Office, and I would more than recommend the report that was done in relation to children primarily with dyslexia, who the challenges that were encountered. And I know that there was a very specialised report done by the Ombudsman for Children's Office, which has really added and contributed greatly to the debate. I think it was from January, is it January?
It was just published in
June.
June.
Published in June, sorry,
right?
June, okay, so even closer, even more recent. I hope that is a document which doesn't follow a long line of other documents and gathers dust on a shelf. And I think it's organisations such as this that will help, perhaps in partnership with the Ombudsman for Children's Office, to move those things along. You have to be very careful, I suppose, to bear in mind that I come from these things from a legal perspective, and that whilst there is lots of correlation between politics and the law, there are certain issues which are best left to advocacy organisations, and then there are some issues that are best left, or should I say, perhaps not best left, but more meaningful change can take place through the legal sphere. I also know that, for example, in very recent times there has been increasing High Court litigation in particular in relation to education issues. I know, for example, that under the Equality Acts, for example, we're seeing a lot more challenges to equal status legislation and equality legislation generally. And bearing in mind that in terms of the issues that we're talking about tonight, the Epson Act of 2004, which has never been implemented in full and which is a very, very progressive piece of legislation, underpins the idea that children with additional needs should be maintained appropriately in mainstream education. But that's not simply enough. It's not simply enough to open the door and to send children in. That's not meaningful participation unless you're sending those children in that they can participate effectively. We hear a huge amount around participation within education. I'm much more interested in looking at participating effectively within education. And if we look at, for example, and I'm sure you've discussed it already, a lot of people who come to me in relation to advocating in their behalf with schools and with state exam commissions and so on, it's around a number of broad themes. And a lot of this is touched upon in the Ombudsman for Children's report. And I'm also struck by the fact that there is, I suppose, two distinct features. One is in relation to supports for children during exam times, whether it's the junior certificate or the leaving certificate. But also we're talking, and I think when I just came in the door, I heard it touched upon, it's about, in fact, long before exams take place, about preparing children properly, not just for the day itself, but for the days and months and years leading up to that particular point. I was speaking at a conference in Kilkenny last Saturday where somebody very senior who has had many, many years of experience within the HSE in terms of diagnostic issues in psychology made the really good point that unfortunately we exist in a system where achievement is not celebrated. So, for example, if your child is succeeding because there is a support in place, then regrettably the solution to that issue seems to be to take away that support then on the basis that they're doing so well that they don't need that particular support anymore. And the parents, and this very much is fed through to me as well, that parents are almost afraid to celebrate achievement because to do so will take away those necessary supports, and when those necessary supports are taken away, we're back in a situation where we're regressing. There's also a fantastic delegation of proper legal authority and proper legal power now to parents themselves. Rather than deal effectively with the child in the school environment, the whole emphasis now is on teaching parents to be the therapist and the teacher and everything else. About 2 years ago, maybe a year ago, and I'd ask people to bear this in mind as well, is that there are so many examples of good practices in education, and then there are so many examples of could do better, and then there are so many examples of absolutely appalling, that when you do look at a really good school and a really well-run school, then that demonstrates one thing, that it can be done. Whereas I am then speaking to teachers and to schools in other areas who tell me it can't be done, and when I point out that in fact it's been done 30 metres down the road or 300 metres down the road, then there's a lot of sort of silence and spluttering on the other end of the phone. I also find, however, that I'm actually getting a lot of referrals now from teachers themselves who are finding it very, very difficult to access for their own schools the types of educational supports that are required. And if teachers are finding the bureaucracy of state exam commissions and departments of education and CNOs and everybody else difficult, then how much more difficult is it for parents who are balancing all of the other things in their lives and in their children's lives? I'm also struck, and I don't mean this to be overcritical, but I'm also struck at the deficit in information that is actually within schools about what is available for their pupils and from their schools. I often ask, although some schools are very reluctant, and all we have to do is threaten the Information Commissioner on them, sometimes it's very difficult to get, and for parents, to get the information from the schools that underpins their decisions and their applications for additional supports. And I'm often struck that, for example, if parents and schools were to work more closely in partnership about putting together the necessary documentation that then is utilised for additional supports, that in fact it would be a much better application. Because unfortunately we also live in a society where because of our waiting list difficulties in relation to a number of various disciplines, parents are now being forced, rather than wanting to, but forced going down the private route in order to get something in order to substitute the long waiting lists. And I'm sorry, but children only get one chance at education, and I know that parents do find it very, very difficult to wait on waiting lists because, of course, early intervention, that key buzzword, where the reality doesn't meet the rhetoric, that has to be in place. And then parents are relying then on private reports, private diagnoses and something, and then they're finding it very difficult because sometimes those aren't even recognised by those that are making the decisions. There's also a contrast, obviously, between junior certificate supports and leaving certificate supports. I'm aware, for example, that in relation to leaving certificate supports, that seems to be overseen, all this anyway, in terms of NEPs and so on, whereas in the junior certificate, it appears to be the case, at least, that schools have greater power and authority in terms of being able to access those supports. It's very unclear whether or not those who are making the decision at leaving certificate level are even aware that, for example, these supports were and are in place at junior cert level. And again, that's a gap in communication between the schools and the departments and the State Exam Commission. And I have come across a number of examples where those that are making the decision at leaving certificate level weren't aware, for example, that these various supports were in junior cert level. Even when you point that out to them, of course, the fallback position is that just because you have something for the leaving certificate just because you had something for the junior certificate doesn't mean that you shouldn't have it, that you should automatically have it for the leaving certificate. And the bizarrest argument of all is that because the leaving certificate is what they consider to be a pivotal exam, which we would all agree, that somehow the rigours afforded to considering whether or not a child gets added supports seems to be even more difficult, whereas I would have thought it would be the other way around, that in fact it is even more crucial that you have those added supports for a crucial exam like a leaving certificate. So there is just a difference in emphasis and a difference in tone. One of the things I think you always need to bear in mind as well is that you do have a legal right, and there are loads of decisions around this, to a proper reasoned decision when you are turned down for a support. And I know that is something that within the Ombudsman for Children's investigations in relation to this area, that was something that I know struck them as well. You are entitled to a fully reasoned decision. You are entitled to a decision that engages with the evidence actually presented. And I have seen this, for example, in the area of domiciliary care allowances, where everyone gets the standard refusal letter without any engagement in evidence. And we have Miss Justice Baker, who now tells the Department of Social Protection, for example, that when somebody applies for something, that a standard rejection letter is not sufficient, that you must actually engage with the evidence that is presented. And the reason you have to engage with the evidence presented is, A, you have to show that you've actually looked at the evidence in the first place. Secondly, then, that you are justifying the decision you're made. But thirdly, and more importantly, that when the parents or schools come to want to appeal something, that you know the basis upon which you're being refused in the first place then informs what you need to do or what type of understanding you have when you come to the appeals process. Can I also say that, and I'm sort of slightly going backwards, and I don't want to be alarmist when I say this either, but for example, I've been involved in cases, for example, albeit not with children with dyslexia, but children with Down syndrome, for example, where together with Down Syndrome Ireland, we took High Court action in respect of 5 families from across Ireland in order to have those children have an equitable right of access to resource teaching hours. We know that resource teaching hours are an educational support rather than a care support. And we know that learning support is lumped in there as well. And we know that there are certain diagnoses that automatically attract resource teaching hours, and there are those where schools can allocate under the general allocation model, the GAM model. It wasn't enough, of course, to be a child with Down syndrome. You also had to have an additional disability on top of that, where there was an educational level of attainment. And we had CNOs, for example, who were saying to parents of children with Down syndrome, well, it would be very helpful if he or she was also blind or deaf as well as being a child with Down syndrome. You were getting into that level of bizarreness. And when parents were able to say, well, they don't have that added diagnosis or that added disability, then the box was ticked no. Now, after a long battle, we won that insofar as there was a special provision made for children with Down syndrome in terms of resource teaching hours. I spoke at a conference in Kilkenny last week, and that followed on, as I say, and there was one of the speakers there that is a whistleblower in the educational sphere. And I know that I had met that whistleblower about a year ago, and on foot of information that I was given by that whistleblower, we made a disclosure to the Department of Education over here in Marlborough Street about 3 or 4 months ago. And what this whistleblower, who works within the special educational sphere, was able to tell rather uncomfortable looking Department of Education officials was that parents who thought that their children were receiving certain assistance in school were in fact not being delivered. So it was all happening on the timetable. It was all legal entitlement to it and assessed need for this. But in fact what we were discovering was that because of a moratorium, and this is particularly prevalent at secondary level, but because of a moratorium on, as a result of the recession, on extra responsibilities for teachers in some school, that when the school principal wanted somebody to do the tuck shop or the rota for the dishwasher in the staff room or whatever it is else that they wanted to do, that when the teachers weren't getting extra increments for that or extra supports for that, that it had to be taken out of somewhere. And what we've discovered, and with lots of evidence, is that unfortunately where it was being targeted was learning support hours and resource hours. And so your child that you thought was being taken out for this extra educational help for 15 minutes a day or half an hour a week was in fact wasn't being delivered. For those, for example, who were being delivered that assistance on a one-to-one basis, was suddenly all being grouped into group hours. So you can have lots of battles for supports, but bear in mind that in fact you always need to keep in mind that that's not the end of the matter, that you should always ensure that those services to which you have a legal entitlement are then in fact being delivered through your schools. So in terms of reasonable accommodations, it's a wonderful phrase, and it's rather flexible in that I'm not sure, and perhaps people will be able to assist me in relation to that. I always find when I go to these things I learn a lot more coming out as well through the question and answer sessions. But I don't know if there is a definition of reasonable accommodations, or whether the list is exhaustive. And as I was coming in, I heard somebody referring to extra time for certain children and so on. So, you know, it is very important that we look at what the assessed needs of particular children are, and we look at, do we have the best evidence to present in order to support either the school or to support that child for making that particular application. As I say, one of the difficulties that I don't understand is that in fact sometimes when parents go to the trouble and the expense of getting private assessments done, that in fact because of this idea, and it's a very laudable objective, but I think it's an excuse that is used not to consider evidence, that in fact what the State Exams Commission's laudable objective is to say that we don't really consider outside reports privately done because it impacts on the equity of access to the scheme as a whole. In my view, legally, they're on very suspect ground in moving that assertion, insofar as you are obliged to consider all of the evidence in relation to that child's individual assessment. And I am slightly worried by the concept that the State Exams Commission or whoever is considering this application doesn't consider that individual child's particular position. And if that means that a particular child or as an assessment has been put in on behalf of a particular child, I am of the view that you are duty bound to consider that evidence in support of the decision or indeed otherwise. I'm also slightly concerned about the fact that great reliance is placed on various standardised testing. And we use the word standardised testing insofar as privately, schools, some schools privately concede that the ability of those people who are administering the standardised teaching, whilst they do have training modules with, I think it may be through the NCSE, I'm not sure, but as to whether or not that is ongoing or not, or whether or not there's any obligation to have it as ongoing continuing professional training or continual professional development, and the communication around how those tests are being applied to the students themselves, it leaves a lot to be desired. And I think that's something that was also referred to in the Ombudsman for Children report. We don't appear from the Department of Education, who of course like to hover up above and blame everybody else. So, but we do need from the centre, from the Department of Education, to absolutely ensure some form of gold star for those who are actually delivering those assessments or those testing, and that's very relevant for children with dyslexia. I was dealing with a mother recently who could never be faulted for her level of commitment to ensuring her child got all of the best supports that was available. And daughter was sitting the leaving certificate this particular summer, had been given the reader during the junior cert exam, had in fact been given the reader for the mock exams, but in fact on exam day number 3 was discussing with her daughter how the exam had gone that day, to be told by the daughter, well, I didn't really understand the questions. To which mum said, well, was the reader not helping you enough? To which the daughter said, there was no reader. So the lack of, and when we very suddenly then had to spring into action in relation to this, we discovered that in fact, whilst the school had indeed applied for and successfully got the junior cert reader, and the school themselves, in fact the State Exams Commission, as it transpires, has no role over the mock exams, that's something done internally, but that the school hadn't then, or had omitted to apply for the reader for the Leaving Certificate exam. Now, needless to say, in day 4 the reader was sitting up, ready to go, but in terms of those 3 missed exams, that was a shocking lack of communication in all directions with the special, with the exam commission, and obviously between the school and the parent. So, as I say, rather than, I'm not suggesting that everybody be sort of hypersensitive or hyper anything, but it's always really important to bear in mind that that ongoing review of the educational supports that are in place is really, really important. And this comes back to what the Epson Act actually envisaged. Epson envisaged at the core of children with additional needs in schools the idea of an individual education plan. Schools and school unions had particular concerns about another layer of bureaucracy, and Epson has never really been fully implemented because, of course, it was all, in order to make it effective and to make it a reality, it had to be matched by funding. And I always use the phrase, the reality never matches the rhetoric, and no greater example of that than the Epson Act of 2004. But bearing in mind as well that what we are seeing now are individual education plans, and they're actually called something else now, but they are now coming in through the back door anyway. Because what Department of Educational circulars are now telling schools is that when you're applying for special needs assistance and resource hours and all of these things, that they should be underpinned by the education plans for those particular children. So what schools are finding is that if they do want the resources, they actually have to put in the education plans for those particular children that they are seeking those resources on behalf of. So that gives a great opportunity for parents who up until this point perhaps didn't have a written plan, and more importantly for children who always respond well to written plans, about the types of expectations, identifying gaps, and how we plug those gaps and assist in relation to children. So I think this is now a great opportunity because of the Department of Education's stance to ensure that parents have input into a proper plan. And I would urge everyone to point that out to their schools if the schools are saying, well, there's no such thing, and nor are we obliged to have an individual education plan, or whatever it is called now. Because the onus is now on schools in order to provide that information in some form of a document. And that allows parents as well great scope to have input into that plan. If that child that I just spoken about in that case study had an individual education plan that was discussed openly, then that would no doubt, that awful scenario that had occurred for that young person would have been entirely avoidable. But because we don't have those as a matter of course, then it has extreme consequences such as that. I'm going to finally, before I finish, just refer to the fact that when we come to events such as this, and when we discuss this in terms of a policy sphere or a legal sphere, however, it's often framed, this debate, in terms of the parent, the school, and the Department of Education. And as a children's rights lawyer, and I said, well, what about the pupil? Because let's put it this way, if you have a child, every child wants to be the same. The goth stage comes much later. Because every child, or most children, love uniformity and consistency and to blend in with everybody else. So to have an additional need or the requirement for an additional support for a child in this points race is very difficult for children. They want to fit in, they want to be the same as the person sitting next to them. And unless from their perspective we are putting in those added supports for them, then like lemmings in terms of educational attainment or educational achievement or fulfilling your educational potential, there is a drawback. And it seems to me that from a child's perspective, if we are being properly child-centred about it, why is it, for example, that you may only be meeting your reader on the day of the most important day of your life? Why is it, from a child's perspective, is it that you can submit all of this information a year in advance, but you may not know right up until the last minute whether or not this added support is going to be made? And for a child, you're factoring in all of those considerations on top of trying to do the revision and the exams and everything else that is part of that process. And the stress on anybody as a young person sitting any type of exam, whether it's the junior cert or the leaving certificate, to have that added pressure and that added element of unknown is an added stress that pupils frankly can do without if we're looking at it from the pupil perspective. And I think if we're looking at holistic planning and all of this type of thing through the individual education plan, we're going to have to be much more creative about actually preparing children for exams, whether it's using your laptop, whether it's extra time, whether it's a reader, whether it's a scribe, whether it's you require larger print on the, if you're only seeing that for the first time, having spent your entire 2-year leaving certificate program doing something differently, to be presented with that on the day of your exam is not child-centred. And I think we're arriving at a particular point where if the policymakers don't get a hold of this and recognise these things, then the courts are going to have to do it for them. It used to be the case in Ireland that the courts took a very hands-off approach when it came to things like education and health and so on. The hospital consultant knows best, therefore we as the court, we won't intervene in relation to things like that. The prison governor knows how to run their prison, therefore we as court shouldn't be telling them how to run their prisons. school principals know how to deliver educational services for their children that are in that school. Therefore, we have to have a much more hands-off approach. That day is coming to an end. And I am also of the view that the idea that these added supports should only be last-minute jobs may also be coming to an end. And there was one very far-reaching example of that was the introduction, only through the courts, of the July provision scheme for children with autism, for example. Because I come from a part of the world where we only had July and August off up in County Fermanagh, whereas you come from a part, I was fascinated when I first came to Dublin 18 years ago about the fact that you all got off much earlier in the year than we did. But in terms of children with autism and consistency and so on, there was this legal argument made to the courts that in fact that break of that length of time without any educational support over the summer months meant that when you came back to school, all the progress that you'd made and the levels that you'd reached was leaving children in a stage where they were almost starting again, and there was a lot of evidence of regression and so on. And what the courts did say in that particular case, which forced the policy change, was the fact that in fact you couldn't have that break in continuity for that length of time, and therefore the July provision scheme for children with autism was introduced in order to try and bridge that particular gap. I'm of the view that an argument could be made along similar lines in terms of this idea that these educational supports around exams are not just at exam time, that in preparing children properly and effectively and to participate effectively in mainstream education, that intervention has to come much earlier than that. So that's an idea to leave you with, and apologies for the delay, and thank you very much for the invite.